P-A-S-C-A-L.
Let's get down to the nitty gritty, okay? Because I know a lot of us are wondering, because, I'm a regular Joe, okay? I talk a lot. This is what I do for a living, right? And we talk about trials a lot, but I'm not somebody who knows the ins and outs of legal. Now, can you go, it's kind of like Law 101, I'm sure, but can you give us a basic explanation of what a status conference hearing is and what it's all about?
Sure. So first off, don't feel bad at all because, part of the system that we have is that every state has a different way of doing things. And so anytime I come across a new case that I'm going to follow, it's a whole process of education for me as well, just because there can be a lot of variation in how things are done. So this status conference, the reason why they scheduled it is because of the way that the procedure works in Idaho for filing a felony charge. They have two ways that a felony charge can be presented. They can have a grand jury indictment, or they can have a complaint that's filed by a prosecutor that then has to go through a preliminary hearing for determination of probable cause to be made by the judge. And so one of those two things has to happen for the case to be able to proceed and a plea to be entered. So in this particular case, there was no grand jury. The prosecutor simply filed a complaint. So given the timing of sort of how all of this went down, he was obviously arrested on the 30th, transported back, had his initial court hearing shortly after that. His public defender had been appointed prior to him being shipped back, but presumably they did not have a whole lot of time to meet and confer and talk about a lot of stuff before they needed to go in for that preliminary, that first appearance. So the issue at this status conference is really going to be, is he going to require this preliminary hearing to be held, or is he going to be willing to waive that and just proceed directly to entering a plea? So that's what I'm expecting to see answered today.
So am I correct? Because, I may be the smartest guy in the world. That's a total joke. I'm an absolute idiot. But I guess my question is, the decision that he and his team makes here, could that give us a small inkling of what they believe 5-0 or law enforcement have or do not have, what the prosecution has or does not have?
Yes, absolutely. And that's the main reason why my prediction is that if he is intending to fight this case and not just, try to negotiate a quick plea that could save his life or, potentially give him some hope of parole someday, as unlikely as that would be, that they will have this preliminary hearing. And the reason why is because it's essentially the state having to put on a case for probable cause. All of this information that they included in their probable cause affidavit, they need to be able to back that up with witnesses in court, with documentary evidence, with things like that that are going to be admissible. So there's a couple of reasons why you do that as a matter of strategy. One, exactly like you said, it flushes out the information that the state has. And so it's an opportunity to potentially get a little bit more detail about the scope of their evidence. The other reason to do it, though, is because it gives you a first look and a first crack at their witnesses. These are going to be proceedings that are under oath, of course. They're going to be preserved. There will be a court reporter, keeping the transcript and everything. And so it's an opportunity to pin these witnesses down to a specific version of events. That's always a key component of trial preparation in a criminal case, because you want to know what you can expect from people. So when you get to trial, I already know what this witness is going to say. And if they deviate from this in any way, I now have this transcript of what they said at the preliminary hearing that I can use to impeach them. So those are the main strategic considerations that I see at play here.
Now, what are the chances of this getting sped up? This trial, what are the chances of Bryan Kohberger's team, the defense, saying, yeah, let's get this moving now? Are the chances high or are the chances low here?
It's a good question. My personal opinion is that the chances are probably low. And the main reason why is just because we have seen how much of the evidence in this case is very technical. It's forensic. It's ping evidence. It's DNA evidence. And of course, we know that the investigation is ongoing. There have been search warrants executed since we got that probable cause affidavit from Idaho. So there's a lot more that police are looking through and analyzing. It's very likely, just given the nature of this case, that he's going to have to pretty carefully analyze all of that and evaluate if there are problems with it, holes with it, things that he can, potentially exploit or just identify as grounds for reasonable doubt in the case. And so that type of thing is very time consuming to get his own experts on board to independently review the DNA, potentially do independent testing, all of that type of thing. It's going to take a lot of preparation. So I don't think it's really in his interest to demand a speedy trial at this point.
Interesting, because it could hinder him as well. It could help him, but it could also, it's a double-edged sword, right? There's a lot of pros, but there's a whole lot of cons as well, because it can screw up the defense in getting their argument more ironclad with probable cause, right?
Yeah,
So,
it's kind of this game, this
reasonable doubt.
chasing game a little bit where, the more time that the reason to invoke the speedy trial is to, limit the time that the state has to be able to build their case, right? Just force them to go before they have all of their ducks in a row.
Yeah.
But you have to be keeping up as well. So it's just going to be that balancing act. With Idaho too, their speedy trial rule is 6 months, which is, from my perspective, quite long. In Washington, if you're in custody, your speedy trial limit is 60 days. So, a state can get a lot done in 6 months. It just kind of cuts a little bit more in favor, in my mind, of making sure that the defense has the time they need to respond to the state's case.
If you were in their shoes on the defense and you were defending this alleged monster, right? Would you want more time, or would you want to say, hey, no, we got enough to fight? If we cut time, that makes them fumble. So let's just get to work. What would be your approach to this whole situation?
Well, it's not out of the realm of possibility that you just go ahead and invoke it now and play kind of a wait and see, go ahead and get our trial date, see where we're at in the close to 6 months or whatever. And if it turns out that, in that time, the state has done all this additional DNA, the state has gotten, evidence from the home, evidence from the car, all this additional stuff that needs to be evaluated, then worry about it then, request a trial continuance and take the time that you need to be able to do that. So there is some ability to kind of play it a little bit both ways in this situation. So that wouldn't necessarily be surprising either.
Yeah, interesting. Real quick, we do have some comments here, so I just wanted to grab them really quick. Faye is the person who got us hooked up on Twitter, and so please follow us on Twitter, guys. What's your Twitter handle, real quick?
It's at A Burkhart Law.
At A Burkhart Law.
Yes.
Okay.
Yes.
There it is. Follow her on Twitter. And of course, shameless plug, follow me, The Pascal Show, one word. But Faye Freeman just said, you guys don't understand how excited I am. I was able to hook these guys up today. So I wanted to say thank you so much, Faye, for making this connection happen. This happened this morning. I'm not kidding. Not kidding at all. Another one, we got a members chat, a members comment. Kimberly in Japan, thank you so much for being a member for the past 2 months. Hi, from Japan. Hi. She said, Andrea is the best. I've learned so much from Andrea. What a great combination with Pascal. Yes, thank you guys so much for your support and your excitement, because I love when I love it when a plan comes together, right? Even ones that happen at the last minute, right? But as far as this trial, as far as this hearing, I mean, it's going to be a fairly quick one. It's going to be kind of in and out. It's going to be very simple, right? It's not like he's going in there. What should we expect? What is the procedure that we should be expecting when he walks into the room?
Yeah. At this point, no, he's not anticipated to enter a plea. What I would expect will happen is that the judge will simply ask if there has been a decision made on the preliminary hearing. and he will indicate if he is waiving or if he intends to have it. If he waives, then they'll schedule the arraignment. In Idaho, that has to be within 30 days. And so they would go ahead and get that on the calendar. That's the point when he would enter his plea. If he requests a preliminary hearing, then they're going to get that scheduled. There is a time limit for that as well, although I forget off the top of my head exactly what it is right now, but it is fairly quick. And so they would then schedule that and basically deal with that hearing before they go through the arraignment. The preliminary hearing, just based on, it's an 18-page probable cause affidavit, and that's just what they had up at the point of the arrest.
Right.
So this could be a pretty extended hearing if he does decide that he wants to go forward with that.
Interesting. I mean, and we're looking at, some people are saying that this could be another year, possibly, where we won't see the likes of BK for a whole year. Would they really hold out for that long to hold this type of trial?
Oh yeah, absolutely. And it wouldn't surprise me if it goes longer. I mean, I haven't been closely following the Daybell case, which is also over there in Idaho, but I think they're in about year 3 of pretrial process. It's just not that uncommon, with a highly technical case like this, so much, review and stuff that needs to be done. And then you add in the fact that this is, likely, in my opinion, to be a capital case. They're probably going to pursue the death penalty or life without parole here.
Oh, yeah.
And so just given the stakes, it kind of, from my perspective as defense counsel, it really puts you in a situation where you have to raise everything. If there's a challenge to be made, you really need to do it, because the stakes are just so high that you can't afford to miss potential opportunities to improve your position. So there could be a lot of pretrial litigation. There could be a lot of investigation that, may ultimately end up going nowhere, but it's just part of what you have to do. Another thing that's going on likely already is, if this does end up being a death penalty case, one of the important things defense counsel has to do is investigate mitigation. And that's basically any facts and circumstances about this guy that would support an argument that, you should go a little bit easier on him for whatever reason. This is often dealing with, circumstances of upbringing, mental health issues, other sorts of problems, other sorts of conflicts. So just really investigating in great detail his life story and the kinds of things that if he did do this, that potentially impacted that. So that's all going on as well, while they're also trying to deal with, just addressing straightforward the merits of the accusations and the evidence that supports them.
Gotcha. One thing, of course, I don't mean to backtrack or go backwards a little bit, but we are going to go backwards, because obviously this is what's happening here right now. They're about to walk into the courtroom as we speak here in just a minute. I'm sure that doesn't seem like court is late, right? But as that's going on, let's go back, okay? Because I'm really excited to have you on, and I have so many questions for you. So if you got some time to bless me, we'd be really, really appreciate. We really appreciate it over here. But let's go all the way back to when he got arrested, okay? And of course, he waived extradition. Now, his defense lawyer, or his lawyer at the time that was representing him in Pennsylvania, was basically saying, like, he's just eager to get back out to Idaho to find out what this evidence is, right? Why would he do something like that? Is that normal to just say, yeah, let's waive it, let me get out there?
Yeah, extradition is almost always waived. And the main reason why is because 99.9 to infinity % of the time, there is really nothing to be gained by contesting it. Extradition it's almost like a diplomatic process. It's an agreement between states that if we have a fugitive within our borders that you're looking for, we're going to hand him over. And so they don't ask questions about the process in the requesting state, or, is your request legitimate? Is this a viable charge? Anything like that. All they care about is, are you the person that was named in this warrant? So that's really the only issue that is typically in dispute in an extradition hearing is identity. So unless he has a viable argument, that he's not the Bryan Kohberger that they're looking for, there's really nothing to be gained from contesting extradition. It buys him time if he's looking for that, but because he didn't have the evidence, he didn't have the probable cause affidavit, wasn't going to get any of that information until he was brought back to Idaho. All he's really getting is some extra time in a Pennsylvania jail, wondering, what the state is basing all this on. So it did not surprise me at all that he waived extradition.
Interesting, because I know a lot of people are looking at this, of course, us regular Joes that don't know anything about law. I think a lot of us have been looking at that and going, ooh, that's an admission of guilt.
Mhm.
He's really nervous. So he wants to know what we know or what law enforcement knows. Let me get out there as soon as possible, because the more they have time, the more they can stick more things to me. Right.
Mhm.
And I feel like a lot of people, yes, are nervous, or not nervous, but I feel like a lot of people have been stuck on the idea of this being an admission of some sort of guilt, like a small inkling of
Mhm.
guilt. But this is just standard procedure.
Yes, I think so. I've had multiple, cases with extradition requests, and I've never contested it. There's just no point to it.
Yeah. Interesting. That's that, and I'm glad you cleared that up. Something else I'd love for you to clear up, okay, which would be great, because this is something that we talked about last night. We did kind of clear it a little bit, but I just wanted to hear it from you as well. I was just wanted to show you guys this title again. We saw this last night. We're going to talk about it again here. They sealed the search warrant for his apartment. They said it could result in premature end of the investigation, which could create a threat to public safety. Now, please, Andrea, explain to me, what the hell does that mean?
Sure. Well, in my opinion, the answer to this question lies in the timing of this search warrant issuance and the sealing process. This was started on December the 29th. So it was before he was arrested and in custody. And so there's a big difference in the legal protection that search warrants and the affidavits and everything like that get under Idaho law and under Washington law. Idaho law has a specific rule that says these things remain confidential until the defendant is served with them. So that's why we had to wait till he was brought back from Pennsylvania to see that probable cause affidavit. In Washington law, search warrants and everything associated with them, these are presumptively public records. They're going to be available for public inspection unless an action like this is taken. So my view of it is that because this was going on in the lead up to his arrest, before it happened, before he hadn't been publicly identified, nobody knew this was coming. They needed to take this step to simply avoid the risk that it would leak out. Somebody would find it, somebody would report on it, and then suddenly this guy is alerted to the fact that, oh my gosh, he's under suspicion, police are coming to look for him. That creates a much more dangerous situation potentially for police doing the arrest. It creates a risk that he could run around trying to destroy evidence. So very important to keep that under wraps until that risk is no longer the case.
Interesting, because I know a lot of people were wondering, maybe undercover cop, or if maybe to protect somebody else that's involved in the investigation. Maybe it's a neighbor, maybe it's somebody, a close friend. Because I mean, I'm sure he had friends, right?
Mhm.
We keep hearing these reports of him being such a charming guy and very talkative and stuff. It's not like he didn't have at least one or two friends that he ran around and maybe shared a beer with or something like that. So I know that there's a lot of people that are wondering about this sealing of these documents, and the fact that you're right, it was filed the day before he was arrested, and it's also only staying up. It may be released by March 1st, allegedly from this article here.
Mhm.
what could make them decide to or unseal these documents sooner? Could
So, yeah, the way that the order is written, they didn't know how long that necessity was going to remain in place, right? They don't know when they're going to find him and catch him. So they put this end date on it of March the 1st, just kind of their best estimate about when that would all be wrapped up. So clearly it happened sooner. And if that is indeed the primary concern that this sealing was intended to address, the order also does provide for the prosecuting attorney to go back to court and ask for it to be unsealed. It's not uncommon also, in high profile cases with a lot of media interest. The media is interested in getting court records and stuff. Not off the table at all that some member of the media would file a motion to unseal as well. So that is potentially something that could happen in the coming days, to make this available sooner than March the 1st.
Interesting. Slim Hauser just said, once he's arraigned, will this be unsealed? Could that be a situation here too? Because
Yeah, I'm not sure that it's going to really have any connection with the arraignment. The way, because Washington law has very, very favorable open court requirements. We have a strong presumption in favor of courts being open, records being public, and things like that. Then that means that if you're going to close off a portion of the process from public view, you have to have a good reason for it, and your closure has to be narrowly tailored to addressing that concern. So then once that concern is no longer the case, the justification for sealing is gone. Really, somebody should be moving to unseal that. So his arraignment is just going to be, his formal announcement of is he going to contest this or is he not going to contest it? I think most of us are expecting that he is going to contest it. So that in and of itself isn't going to affect, whether there's a public safety issue implicated by releasing this information. So I think it will likely be independent of that process.
But let's talk about a couple other things, okay? Obviously, if they decide or don't decide to have a speedy trial, obviously that's up to Bryan Kohberger's team, and obviously that will tell us a little bit of something. I mean, I think, right? Either he is feeling very cocky and saying, "Hey, let's see what you got," or it might be like, "No, let's wait. Let's work on our defense really quick," because of course they still have they can still lean on reasonable doubt
Mhm.
like crazy right now. So let's talk about this lovely affidavit, right? This heavily redacted affidavit. I swear to God, that thing could have been 50 pages. That's what it looked like. Because there's so many other accounts, like Bethany's account. We hear nothing of hers at all, except for a little bit, like a line or two about how she knew about the four of them going off and doing their respective things that particular night. We hear a lot from Dylan's account and all that, but you can see it's heavily redacted. Now, obviously, we've talked about this before on the show, but of course, I want to hear your professional opinion on this. Why was it so heavily redacted? Why not just give everything out there, warts and all?
Well, it's normal for an affidavit like this to be relatively bare bones, and that's just really a factor of its purpose and its function. This is something that they have to file just to establish there is reasonable grounds under all of these facts and circumstances to believe that this is the person who committed these crimes, and so it supports proceeding with the charges. So it's it's not too surprising to me that they're not going to show all of their cards, right? This is clearly not the full investigative report. We don't see anything about like all the people that they talked to that provided no useful information, uh, grounds that they went down and investigated to pick up little pieces here and there. They may have a fair amount of information that they haven't figured out yet how it fits into the total picture. One of the things I'm kind of interested in seeing more about is what if anything did the people in the restaurant where I believe it was Maddie and Xana were employees in downtown Moscow.
Mhm.
It's one of those situations where that's an opportunity potentially that the connection could have been made with Mr. Kohberger. These are other people besides their school companions that they may have had conversations with. So it's a potential source of information, insight into how and why this happened that we really know nothing at all about at this point in time. So there's likely to be lots of stuff like that police have already done, but they're not including it in this affidavit because they aren't at a point yet where it, clearly indicates that he's likely, the one that did it. So they just limited it to the stuff that is really the strongest, the most direct, gives them the best circumstantial picture to be able to connect those dots, right? His phone pinged outside, his car pings with his phone, his car was seen in the area, et cetera, et cetera.
Yeah, and that's the thing though. When we look at all those things within the affidavit,
Mhm.
I guess the burning question is it enough? You got
Mhm.
the knife sheath,
Mhm.
the K-bar sheath, you got some pings, okay?
Mhm.
You got some surveillance video, but is that enough
Mhm.
for is that a strong enough argument to say that this man is guilty of these heinous crimes?
Mhm. Well, I think that's a great question. For me as a defense lawyer, when I read this affidavit, it's clearly enough to arrest him. It's clearly enough to support the charge. The probable cause standard is pretty low. But proof beyond a reasonable doubt, I don't know about that. I mean, I see potential avenues for those conclusions to be questioned. I've made the comment that this is a circumstantial case. And I don't mean that in a bad way, like that's not a legal defect or anything like that. Most cases are circumstantial, at least to some extent. What I mean by that is essentially direct evidence is stuff like being caught on video camera, having an eyewitness seeing you commit the crime, confessing to the crime. These things directly prove it. Without that type of evidence, you're looking at the total circumstances and what sort of inferences you can draw from that. What makes sense as an interpretation of this evidence? So there's clearly a interpretation of this evidence that favors the state's position that yes, Bryan Kohberger drove the car, with his phone and committed these crimes. But there are, potential ways that some of that could be explained away. There are potential issues that we don't know with the strength of this evidence. For example, the DNA match to the father. DNA often sounds like it's a pretty black and white type of issue, but it really isn't. There can be concerns about quantity and quality of the DNA evidence that
Hmm.
will shed some light potentially on how it got there. So, like, for example, a small amount of DNA that's of poor quality may be more likely to be what's called touch DNA or transfer DNA, where it's not necessarily there because the person touched it directly. It's because something came into contact with their DNA and then deposited it on that item. So all that type of stuff is going to be evaluated. Of course, the fact that this DNA was found on a knife sheath, that looks bad, but a knife sheath is a pretty mobile item. There, can be explanations potentially for how it came to be there. So these are just things that until we get a chance to see what his version is, I mean, if he doesn't just rest on his Fifth Amendment and not present any affirmative case, just work on poking holes in the state's case, which he may do. But if he does present some sort of affirmative evidence on his own behalf, we have no idea what that could be. We don't know if he's got an alibi. We don't know if he's got an explanation for how the knife got there, why his car was in the area. All that type of thing is a mystery still.
Interesting. Yeah, because I mean, obviously they can really, really lean hard on reasonable doubt, especially if this is all that they have. If all
Mhm.
that they have is this and this
Mhm.
alone, just
Mhm.
the pings and a sheath and all that, you can throw in reasonable doubt that somebody could have walked in there and just dropped it in
Mhm.
there just to try to pin this guy. As far as the pings, I mean, shoot, it's a small town. It's
Mhm.
nearby his university that he is studying criminology and criminal justice from, where he's a TA at. maybe he likes going into that town to grab the best coffee around, or there's a vegan spot. It's the Mad Greek. He just happens to go to that spot, so on and so forth. It's pretty wild, the amount of reasonable doubt that they have. And we are going to talk about more of the evidence or like the weapon here in just a second. But there is some new updates here, guys, which I wanted to show you guys really, really quick. This is from Brian Enton. All right, let me blow this up so you guys can see a little bit more. It says Bryan Kohberger's preliminary hearing has been set for June 26th at 9 a.m. He was in court today in an orange T-shirt and told the court he waived his right to a speedy preliminary hearing, no bail. So, Andrea, thank God you're here. Can you give us the layman's terms of this? Can you break this down for us layman's?
Yeah, so under the Idaho rules, he's entitled to have a preliminary hearing as soon as I think like next week or the week after, like very, very soon. It's based on the time from his first appearance. So he has clearly waived that. He's saying, no, you don't have to do it immediately. We'll do it down the road. My theory about why they did this, because the probable cause is not going to be limited to just what they had at the time of the arrest, to what's in the affidavit. They just need to support the charge and justify the bringing of the charge. So they can use anything and everything that they have acquired since that point to support that case. So this tells me that he is waiting for some more of that work to be done. He already knows it's coming, right? He already knows they've gone through his apartment at WSU. They've gone through his car. They've probably gone through his cell phone and all his computers and stuff like that. So for those reasons we talked about before, the advantages of having the preliminary hearing, it gives you your shot at the evidence, at the witnesses. You get to feel out, who's a good witness, who's not a good witness. How do I pin them down to what's going to be helpful to me when this case comes to trial? It makes sense for them to get the most out of that they possibly can. So knowing that those types of issues are going to be presented at the trial, then let's go ahead and use the preliminary hearing to be able to get a feel for that as well.
Interesting. So we won't hear anything of Bryan Kohberger for about 6 months ish.
Yeah, unless something comes up, as like a preliminary motion or something like that gets filed, then yeah, this case could go silent for a while.
Now, is this considered? I mean, he waived his right to a speedy preliminary hearing. So, is this standard? Like this 5-month lull? Is this standard procedure, or could he have had a longer wait, maybe a year?
Mhm. A year would probably be a little bit long, just because the court is going to want to keep this moving. He's not gonna want them to drag their feet and avoid the inevitable forever. But at the same time, he's going to want to give him a fair shot to be able to defend himself. That is his constitutional right, and the court's not going to get in the way of that. So it's longer than I think in a normal case, a case that's not potentially capital, a case that doesn't have this type of profile. I would be looking at that as wow, that's a pretty long continuance. But just given the circumstances here, it doesn't strike me as really out of line.
Interesting. So he just took the standard. He took the regular standard approach to everything. So he obviously, it sounds like he wants more time for his defense team to come up with a stronger argument, right? And this also gives prosecution more time to fill up their argument as well. Like, get the murder weapon. Now, let's talk about that here really quick. And before I do that, Jim Halpert, I want to say a big thank you to Jim Halpert for gifting 5 memberships. I really do appreciate it. Welcome to the family, Christina, Gina May, Tia Kazan, and Sushi Jezebel, Wendy Knutson. Thank you so much for becoming a member. And thank you so much to Jim Halpert for gifting them those memberships. Please give him a whole bunch of purple heart emojis if you can, on behalf of myself and of course the channel. Okay. And I'll be getting to all the other memberships and all that stuff in just a second. But let's talk about this here. Where's the murder weapon? Asking for a friend.
Yeah.
Delete later. I mean, what's going on here? I understand that the affidavit had enough in there to pin some things on him for probable cause to bring this guy in as the bad guy, but they don't have the murder weapon. Now, when it comes to that, I've asked this many times and I'm going to say it again. Is this enough? Like, without having this, how can they stick it to this monster, alleged
Mhm.
monster?
hmm Well, it's one of those things that's kind of like motive. It's not technically required to prove that somebody committed the crime, but it sure is helpful information. I mean, if you as a juror are sitting on this case and trying to make sense of what happened here, you would like to know that. So I am confident that the police are leaving no stone unturned trying to find this murder weapon. They have looked in his apartment, they looked in the car, they looked at his parents' house. They are very likely, trying to trace back these routes of travel that he took at the time of the killing, and then also in the surrounding days, to try to see, is there somewhere here that he may have dumped it that we would be able to recover it from. I remember a reference in the probable cause affidavit to him going down to Clarkston, which is right on the Columbia River, but very very large river in that particular area. Lots of potential places that he could have dumped it. I'm sure they're going to try to find it, but it's possible that they don't. If they don't, it's going to be an unfortunate hole in the total picture of the case. I don't think it's fatal. Uh, Cases are fairly commonly tried without a murder weapon, and occasionally even without a body. But it just does make it that much harder because they have to have a more compelling circumstantial case, a much more uniform conclusion that points directly at him and doesn't allow for other alternative explanations.
Yeah. And of course, we're looking at some video that was from today's hearing, from today's status conference hearing. You can see he even got a haircut and all that. It looks like, at least, it looks like he got a haircut recently from the last time we saw him, unless his head is shrunk. I don't know what to tell y'all, but it looks like he got a haircut. But this is from inside right now. As you can see, the trial did happen. They were in the house talking about this whole thing. Of course, now the preliminary hearing is going to happen on the 26th of June. So they got 5 months to get their ish together on both sides of the fence. Let's not forget that. And so we're going to see what happens here. Now, what are the chances of him walking? With
It's
if they don't
Yeah,
show up with the murder weapon, so on and so forth. What are
yeah.
the chances?
It's really, I hate to dodge like this, but it's just impossible to say at this point because there is so much that we don't know. There are so many ways that this case could go. Like I said, he could have evidence of an alibi. He could have himself and his cell data at a location somewhere completely different, than these murders at the time that they happened. Uh, we won't find that out until quite a bit later in the process. uh, on the other hand, all of this stuff, who the police could have found, they could have found the murder weapon, they could have found a confession, they could have found photographs, they could have found trophies, they could have found DNA from the victims, in his apartment. There's just a lot of things that could still happen that could really determine the direction that this case is likely to go one way or the other. So just given that our information is so preliminary at this point, I don't think we can really make a prediction. Once we have this preliminary hearing, then I think we're going to be in a much stronger position to evaluate that.
Mm, man, man, oh man. Well, Andrea, I want to say thank you so much for coming on and just being a part of the conversation because, again, there's so many things that we are still trying to figure out. Obviously, as this trial comes forward in 5 months' time, um, I'm sure there's going to be more information that's going to be popping off, coming out, which we're going to have a lot of questions for. And I know that you're already doing a lot onto your own channel, which of course I want to pull up and show everybody again. And so please, guys, you guys got to go over to Andrea's YouTube channel, Andrea Burkhart. It's at A Burkhart Law on Twitter as well. Go follow her, give her some love, let her know that I sent you. Okay. She has been doing an amazing job, as you guys can see, the content that she has been putting out. I mean, she just put something out an hour ago, guys. This is how much work she's been putting in on not only just this particular case, but on many other cases as well. So please go and follow her, give her some love. She rightfully deserves it. Okay. But again, Andrea, I want to say a big thank you again for coming on and just giving us some more, just helping us understand a little bit more, or helping me understand a little bit more. Everybody else, they're the smartest people in the room, in the chat room. But me, I'm just the fool. So I appreciate you giving me some more information so I understand what to expect here, and hopefully we get justice. Right? Mm-hmm. I'm hoping that we get justice. Oh, you know what? One more question. What are the chances of law enforcement actually having said weapon and they just haven't put it out there? Does that seem a bit odd to you if they were holding that back?
Well, it's definitely possible. I would expect that if they had recovered the weapon at the time of the arrest, that we would know that it would be in the probable cause affidavit, because something about the circumstances of them recovering it would have tended to implicate him, right? They would have found his DNA on it, or they would have, found it in the vicinity of where his car was driving or something like that. So it would have added to that circumstantial case for guilt. If they have found it since then, though, I don't think we're going to know, at least until we get to this preliminary hearing, because of that gag order that is in effect in Idaho. So the police aren't going to be able to tell us if they found it. So
wait, so
that's $1 million question.
So that's the other question, though, too, the gag order. Okay. Mm-hmm. From my understanding, this was kind of the debate that was going on last night's show. Does this mean the gag order is in effect, like, starting today, or as soon as the gag order was filed? Because a lot of people are like, wait a second, as soon as the trial starts, then the gag order is in full effect. Some other people are like, no, as soon as it's filed, law enforcement can't talk to nobody anymore now. Which one is it?
It's a good question. In fact, I'm going to just go ahead and pull it up myself over here so I can look at it for sure. Yeah. But I read it as being in effect instantly. And I get that from the language that it is hereby ordered. He's saying right now, if he were intending to make it effective at a later point, it would clearly say that in the order. So he's saying it's as of now, and it's going to remain in full force and effect throughout these proceedings until such time as a verdict has been returned, unless modified by this court. So yeah, I read it as it's in effect, and it's going to stay in effect unless and until they enter some new order.
Really interesting. So if they even, because law enforcement would love to be able to have press conference and hold the knife up and go, here it is, everybody. Like, we just caught this big old fish. You know what I'm saying? So even if they caught the big fish, they can't even show it off right now.
Nope.
Wow.
Nope.
That's terrible. Until they present it in court. And then, of course, in court, we can hear about it and, of course, talk about it when it's presented in court, if it's presented in court.
If you'd like, sometime I'll come back and we can talk specifically about this gag order. I have about 1,000,001 problems with it. I understand, the incentives for it and stuff, but it's just a very messy and complicated situation. So I'm kind of skeptical about how effective it's ultimately going to end up being. But there's a lot to talk about with that, so we'll save it for another time.
Okay. Yeah, I know you got to jump off and you got some things you got to take care of yourself. But again, Andrea, I really do appreciate you coming onto the show, giving us your legal expertise and all that. It really does mean a lot. Again, guys, please go and follow her on her YouTube channel. There it is, Andrea Burkhart. It's very, very simple. Go follow her on her socials as well. Okay. And hopefully we will have her back on in the very near future again, because trust me, there are other trials going on and there's other evildoers out here in this world getting caught every doggone day. So Andrea, I really do appreciate you coming on, and enjoy the rest of your day. All right.
Thanks so much for the invite. It's been a great time.
Pascal, you are now rocking with that dude Pascal. We be going wild.